Welcome, everyone. Today, I'm really happy to be joined in the studio by Jo Sherman, CEO of EDT. And today, we're going to talk, this will be the first part of a two-part interview on the collapse of Safe Harbor after Schrems, what this means for internal investigations. So, Jo, welcome to the studio today.
Thanks, Richard.
And why don't you tell us a little bit about yourself and what got you into the safe harbor world, so to speak?
Sure, okay, drowning in the waters. I'm a lawyer by training. I studied law and computer science a few decades ago, and for the last 25 years I've been working in the application of technology to law, and occasionally in reverse. So the legal technology space has been mine for an area I've worked in for 25 years, and that incorporates roles within law societies, law firms, government agencies, courts. I've done a lot of work in Commonwealth countries, in particular on court reform, information management, information governance in the courts, and a broad range of things.
Well, tell us a little bit about EDT.
EDT is a company I founded about 14 years ago in Australia in response to an observation that I made in a project that I was involved in where the law firm was struggling with the management of electronic data for litigation purposes. So we developed our software in those days. I remember saying at the time, this shouldn't take too long. Right. Let's develop some software here. Give me a few months and I'll have a prototype for you. I remember saying that to one of our clients, and here we are 14 years later.
14 years later.
Yeah.
Right.
So it's software that's designed for litigation and investigations.
Okay. Well, jumping a little bit into current events, there's been a lot of publicity about the Schrems decision and the changes in Safe Harbor. What do you think this decision is all about? And up front, I am not technologically savvy, so
Sure.
Feel free to dumb down
Sure.
all of your answers. I won't
Sure.
be offended.
Sure. Okay. Well, the reason I find it quite interesting, first of all, I think from a almost a philosophical perspective, it's pretty interesting because we've got privacy and security sort of coming up almost at loggerheads in terms of philosophical perspectives from the US and the EU. You could interpret it in that way, I suppose, because the different regimes of each jurisdiction are being a little bit challenged in terms of data protection at the moment. There's a lot of discussion about alternatives to Safe Harbor because Safe Harbor was the mechanism through which data was transferred from the EU to the US. That is, data containing personal information was given safe passage to the US because of the Safe Harbor certification, which is a self-certification process for companies that are bringing data across the Atlantic. And that's been in place for 15 years, and it was put in place because there was a perception that there weren't adequate safeguards in the US for personal privacy. And certainly what's happened over recent years is that fear, I suppose, has been heightened by some fairly obvious events that have taken place. And the Schrems decision actually brought that to a head. So I think what's really interesting, though, is there's a lot of talk about movement of the data across the Atlantic from the EU, and there is an opportunity to look at things a little bit differently.
So what do you think this means for internal investigations and litigation?
Well, I think that we need to rethink our processes. We need to think a bit differently about the way we've been approaching litigation and investigations, because traditionally all the data was gathered in the EU, if there was EU data relevant to the case, and then it was shipped back under the Safe Harbor protections usually to the US so that it could be processed, analysed, culled, reviewed, and then produced to a regulator or to the other side, depending upon whether you're dealing with an investigation or discovery. But what's happened now is that transfer of data is going to be a lot more challenging. So I think there's a need for us to think about doing more in the EU and starting to rethink our workflows, rethink our resourcing, and rethink the tools that we're using to actually service these particular projects.
Well, that leads a little bit into an FCPA blog piece that you wrote, and your proposition was to take the tools to the data in order to remain compliant with Safe Harbor EU data protection. Can you tell us a little bit about that?
Sure. What we've actually been pretty focused on at EDT for a long time is developing one integrated platform, one software platform that does everything from processing data to early analysis of the data to review and production all on one integrated database at the back end and one integrated software platform. Now, the benefit of that is that it's a much simpler scenario to actually move this entire application into a remote location or to make it a portable solution so that it can be taken to the data as an all-in-one solution.
Well, we're talking about this in the context of the safe harbor ruling, but are there other situations that might benefit from this sort of mobile approach that you're talking about?
Sure. I think sometimes it's also beneficial in situations where there's a lot of sensitivity within a corporation about data going off-site. Sometimes it's quite beneficial to send the tools to the location of the data so that the project can be run internally and a little bit more discreetly than the notion of the forensic investigators coming in with their kits and going around collecting all the data. So it's a little bit easier to run an investigation or to do work on site if you've got the entire platform which will support all of those different activities, the processing, analysis, review, production, all on site so that the whole process can be effectively done.
And are there technological and human resources in Europe to be able to do this kind of work?
Absolutely. Believe it or not, there are some very capable people in Europe. And many international law firms also have very well-equipped offices in the EU, of course, that have they have great skill sets available to them. So it's not out of the question that these projects could be done locally.
So it's just tapping into those resources.
That's right. And in fact, some of the benefits that also come from running projects locally are relevant to the issue of privacy. So, for example, if you're working on site with the data owner or the data subject, you can get a lot more insight into the characteristics of the data. Where is their personal data located? Were they keeping it in a particular folder? Can we quarantine that folder and prevent that from being collected and produced? Can we redact the information locally? Can they help us work out where other repositories of potentially relevant data are? So actually doing more on site and talking to the people that are responsible for the capture or the actual data owners themselves is sometimes a more powerful way to go.
Well, it sounds like there's some additional benefits than just the collection of data in doing it this way.
Absolutely.
And what about cloud-based services providers?
Sure.
Is that another portable solution? And again, just as I try to conceptualize a remote server, which is what a cloud is, can that be walled off geographically?
Well, I think it's interesting because sometimes people think that the cloud is this amorphous sort of white fluffy thing up there that holds data in a very unstructured way. But the fact is that the cloud is just a series of data, a series of file servers and data repositories. And depending upon which cloud service provider you use, you can actually mandate where you want your data to be located. We, for example, have teamed up with IBM SoftLayer in order to deliver our cloud-based solution in the EU. So data can reside in a number of data centres in the EU. It doesn't need to come out of the EU. And it's quite possible to actually, therefore, if you don't want to do the portable model of taking the software into the organisation, you can actually locate the data in the EU, and via our partnership with Kraft Kennedy, a great partner that has worked with us on this solution, they're very capable in terms of delivering the support for the cloud environment and the EDT software within that context.
And presumably that's a certifiable process that you can demonstrate to the regulators that there's been no breach of this ruling.
Yeah.
Well, great. Well, thank you for joining us, and we'll look forward to part 2, Jo.
Thank you.
Thank you.
Thanks, Richard.